Hello, everyone. Welcome to the last webinar given by SunRay Construction Solutions and the fabulous board-certified construction attorney, Alex Barthet, on my subcontractor or sub-sub is not performing. What are my options? I'm Ariella Wagner, the founder of SunRay Construction Solutions. We help thousands of subcontractors and suppliers secure their lien and bond claim rights. And without further ado, we'll start our last webinar of 2020. And Alex Barthet, please take the stage.
Thank you, Ariella. My name is Alex Barthet. I'm a board-certified construction lawyer, and today we're going to talk about how to deal with a subcontractor, or if you're a sub and you hire a sub-sub, how to deal with them if things aren't going quite right. And we're going to break this down into a couple of key parts. One, in today's agenda, we're going to talk about why having a good contract in writing is so important. Two, we'll talk about considering having your subs get bonded, something that you may not have considered before. I'll explain to you the process, the benefits, and the cost. Then we'll start to break down the process of what to do if something goes wrong. So we'll start with the notice and default process that may be in the subcontract. We'll talk about the importance of documentation. You also have to always be ready that if you're going to terminate or default your sub, what does that mean for the project? Are they going to file a lien? Is there going to be a lawsuit? We'll talk about those issues. And then what do you do if you have no written contract, or you've only signed a scant proposal that was given to you? How do you deal with those issues with your subcontractor? And as always, we will answer any questions that you have. To ask your questions, use the GoToWebinar chat box. Please do not include the names of any people or companies in your questions. We will answer all the questions at the end, but you can go ahead and submit them at any time. So let's get started. It is absolutely critical that you start with a good, ideally in writing, subcontract. Let's talk about the key components of your subcontract that you should consider if you're going to either modify the contract you have or create one because you're not using one. So the first thing that you need to know is that if all you're doing now is signing the proposals that are given to you by your subcontractors, you are leaving a lot of advantages on the table, meaning there's a lot more you can do to improve your legal position than signing that proposal. It probably has either very few terms, or the terms that it does have are likely good for them and not good for you. So you want to prepare your own standard form of subcontract so that when you hire a subcontractor or a sub-subcontractor, they're signing your form. Now, don't get me wrong, it doesn't have to be a 10, 15-page agreement. There's lots of things that you can do in a one-page agreement that are better than having nothing. So let's go over what some of those terms are. Obviously, you want it in writing. If you've signed a prime contract, or if you're a subcontractor, you've signed a subcontract, you want to incorporate all of those terms by reference into this agreement. So all of the obligations that you have to the owner, for example, you want to make sure that your subcontractor is responsible for those things. You want to clearly define the payment terms. Are you going to include a pay when paid provision? You can go through the SunRay YouTube channel or on their website. We've done many presentations on pay when paid provisions and how to do them right and where we see mistakes happen. So if you want to have your obligation to pay your sub contingent on your receipt of payment, then you need to have a pay when paid provision, and you have to do that in writing, and it has to be done correctly with certain magic language. You also want to make sure that if there's a dispute during the course of the project, your subcontractor does not have the right to stop working. The only way you can do that is to have a provision in your contract that prevents them from stopping work if they are not paid or if there's a dispute. You have a schedule with the owner or the contractor to get your work done. You need to incorporate that schedule, the start date and the end date, at a minimum with your subcontractor or sub-subcontractor. If not, meaning if you do not have a provision in your contract that requires that this work be done by a certain amount of time, either a duration or a schedule, then there is no legal obligation for that subcontractor to be done by that date. So you may have committed that you're going to be done by December 31st, but if your written agreement with your subcontractor doesn't say that he or she is also responsible to be done by that date, then the court, the law will impose just a reasonable amount of time, which may be January, February, March, who knows? So if you want a schedule or a start and end date, you need to put that in the agreement. And if you want a penalty, liquidated damages associated with being late, you also need to include that in your agreement. Indemnity and hold harmless is very important. That means if they do something wrong and you are damaged as a result, you have the legal right to go after them. Having an indemnity and hold harmless provision in your subcontract is very important so that if something does go wrong, you can go after them legally. Now, what about insurance? Have you defined the types and amounts of insurance that you're expecting your subcontractor to have? If you sign their proposal and it says nothing about insurance, then they may have the minimum or no insurance. And you also want to make sure that you get the certificate of insurance from the subcontractor's broker. We have cases every once in a while where our client has a claim, believes that their sub or sub-subcontractor has insurance. They give us the certificate of insurance only for us to find out later that it was completely fabricated, that the certificate of insurance was just printed by this fly-by-night subcontractor, and there is no insurance. The policy number doesn't relate to a policy issued by that carrier. So one of the ways to minimize that risk is when you request the certificate of insurance that the broker give you the certificate. You don't get it from the sub, him or herself. You also want to include a notice to cure and a default provision. So what time period do you need to give for the subcontractor to cure any default, and what are the conditions for terminating the subcontractor? You also want to include a provision about terminating for convenience, meaning terminating for no reason whatsoever. This is always a great out for you, meaning, maybe they're not doing anything specifically to breach the contract, but maybe you found someone with a better price, you're just not happy with their work. Legally, you don't have a great case. So, you're going to terminate them for convenience, which means terminate them for no reason at all. But you can only do that if you have a provision in your contract that gives you that right. So at a high level, these are the types of things you want in your subcontract to better protect you. Let me tell you about one little pro tip that makes a big difference at reducing claims, and that is getting a release every time you make a payment. Now, the form of release that's on the screen now is a broader release than what would be considered a lien release. And if you look at it, it includes provisions that what I would say would be a general release. So it says that not only is the sub releasing their lien rights, but they're releasing any rights for claims, change orders, works, materials, delays, fees, costs, losses, expenses, damages, or sums for the labor, services, and equipment furnished. Meaning they're releasing anything and everything prior to the through date that they may have. Now, the reason this is really important is sometimes we have clients come to us and they have a dispute with a sub or a sub-sub, and we say, well, can you give us a copy of the releases that you were getting? And they either have no releases or the releases that they're getting are not very well written. And what it does is it gives the sub the right to make a claim for things that may have happened in the past prior to the payment. By getting a release like the one you see here, every time you make a payment, you know that at least as to the through date back, you're kind of wiping the slate clean. You know that anything that could exist prior to that through date is being released. So you don't have to worry about it. And if they try to bring a claim or a lien or submit a change order for extra work or extra time or extra money, you can say, I'm not going to pay it. You gave me a release that said that you weren't owed anything for that period of time. So getting a release like this every time you make a payment should be good comfort for you to know that everything prior to that date has been taken care of. So let's move on to the next step, which is consider having your subs get bonded. So what does that mean, to get a sub bonded? What happens if you default a sub, they cause lots of damage, you're out of pocket an extra 10, 20, 50, $100,000 because of the work that they did that was no good, late, has to be redone, but they don't have any money. It's pretty much a few guys and a truck, and if you sue them to try to collect $100,000 that you were damaged, you're not going to get anything. The way to remedy that is to get them to give you a payment and performance bond. You, as a sub or GC, you may be bonded. You can get your subs to bond to you. It usually costs between 1% to 3% of the contract value. And the benefit, obviously, is that if there is a claim, you have a surety bond to go after. And that protection may be significant, especially if the subcontractor has no real assets. I would suggest to you that on projects where that trade is doing work of significance or that is subject to claims in the future, you consider getting that sub bonded. So, for example, you're building a warehouse and it has a big roof, and that's an area of risk for you, meaning if the roof wasn't done correctly, there are leaks in the roof, having to redo that roof, or if there is a leak, having a bond for that sub makes a big difference. It gives you some peace of mind. So I'm not suggesting you bond every trade, but maybe you bond some key trades. And if you have the ability to price it correctly, you may be able to get the owner to pay the cost of these bonds as well as part of your contract price. Just know that smaller subs usually can get bonded up to $500,000, maybe even more, slightly more, with just good credit. They don't have to have a lot of cash in the bank or assets. So consider that when you're asking a sub to get bonded. Don't just think, well, he's too small or she's too small, they're never going to be able to get bonded. If the contract is small, a couple $100,000, they should be able to get bonded just based on their credit alone. Next, you need to follow the notice and default process in the contract. So what is that notice and default process? Take a look at your contract. What does it say? What do you need to do? You need to provide all of the required notices and never ever skimp on those notices. Always err on the side of more notices rather than fewer notices. if there's ever going to be litigation related to this claim, you want to be able to say that you gave every opportunity to this sub to do the right thing, and they didn't. The contract may say how notices need to be sent. You need to follow that process. Even if it says to only send it certified mail, for example, I recommend that you send it via email and certified mail. If it says fax and regular mail, you should send it fax and regular mail and email. There's never any harm in sending it more ways than the contract requires. And if the contract is silent on how notice should be sent, my advice would be send it via email and certified mail. Documentation is absolutely critical if you're going to consider terminating your subcontractor. If there's going to be an argument, whether it's out of court or in court, in my experience, having done this for more than 20 years, the party that usually wins that argument is the one that has the better documentation. Knowing that, plan accordingly to document what is happening and why you're defaulting this subcontractor. Written notices to cure are absolutely critical. So make sure that you provide those written notices often. Photos. I cannot overstate the importance of photos to support your claim. Having those photos over time is going to be, what I would tell you would be the linchpin of your case. If we get to court because you've defaulted the sub and there's a lawsuit and you don't have photos, it is very hard to convince the judge or the jury about what was going on, because we don't typically, at that point, everything's been covered up, everything's been done or redone, the site has been occupied, it's been turned over to a new owner. You're not going to be able to tell a good story and explain to someone that knows nothing about construction what went wrong without those photos. So taking lots of pictures is critical. If you are going to do any work to redo the defective work, you're going to rip out their defective work, you're going to fix it, you're going to cover it up, I strongly encourage you to provide written notice to the sub that they have the opportunity to come and inspect as you do the work or before you cover it up, so that they cannot come back later and argue what's called spoliation of evidence. Hey, had I known you were going to do that, I would have come to look, because now all of that evidence is gone, and therefore I can't make, the evidence has disappeared. So to avoid that claim, which usually is not a valid claim, but it's one that you'll have to deal with if it's brought up, the way to minimize that claim or avoid it is to just provide that notice. In my experience, most folks never show up, but giving the notice prevents them from arguing later that they should have been given the notice or they would have shown up. At the beginning of this process, you need to segregate all of your costs for the supplementation of this subcontractor. When a claim is going to be made in the future, know that your damages are going to be based on what additional costs you incurred as a result of their default. So for example, if you have your crew of people and you default your sub, and you're going to now have to spend more money managing a new sub, you have to do extra work, and maybe the existing subcontractors are going to have to do extra work. It's critical that all of those costs related to the default or termination of the sub get itemized separately from the rest of the cost of the work. If you don't do that at the beginning, Trust me when I tell you, it's almost impossible to do at the end if you haven't set up your accounting system and your documentation to segregate those costs. Next, be ready for liens, claims, and lawsuits, unfortunately. If you default the sub, you have to be ready for what's going to come next. You need to expect that there may be a lien on the property by this defaulted sub or a lawsuit. How will that impact the project and future payments? Many times, if you terminate a sub, they may place a lien on the project. That lien may prevent the owner from funding you or prevent the lender from funding the owner, and therefore prevent you from getting paid. How are you going to be able to deal with those things? Don't just think, I got to get rid of this sub. Whatever it takes, I'm going to get rid of him or her, without thinking 2 or 3 or 4 steps down the line about what are the things that could happen and are you going to be ready to deal with them. It's not the end of the world that a sub puts a lien, even if it's a fraudulent lien, on your project, but you need to be ready to bond it off. And to bond it off, you need to have a surety bond ready to go. So if you're thinking you're going to terminate a subcontractor, have you taken the steps necessary in advance to get ready to issue a transfer bond in case they place a lien on the project? If they make a claim against the owner, are you ready to indemnify the owner? Again, none of this is insurmountable, but the key is that you need to make sure that you think about it and that you plan accordingly. Finally, what do you do if you have no written contract at all? Meaning you just signed a proposal or you have a handshake with this subcontractor and you want to terminate them. What are the rules of the game? How do you deal with that? Let's go through it step by step. You need to understand the limitations that exist when you have no written agreement with this subcontractor. There's no schedule. There's no completion date. There's no limit on the scope or the changes. So to the extent that the sub is running late and you believe that's the basis of a default, it may legally, it may not be, because if there's no date certain in the contract when they have to finish, the fact that they're running late doesn't mean that you have a legal right to terminate them for being late. So again, you need to understand what your limitations are. Same with a poorly defined scope of work. You understood the scope included X. They said, no, it didn't. Here's a change order for $10,000. You say, I'm not paying that. And now you want to fight over whether that constitutes a default. Again, you need to understand, if you don't have a clearly defined scope of work in your contract with this sub, then if they submit a change order, it's going to be he said, she said on what truly was the scope of their original contract. If there's a dispute over payment and the sub says, I'm not going to keep working if you don't pay me, if you don't have a written contract that requires them to keep working, they may have the legal right to stop working if you don't pay them. So understand that that may be a limitation on your ability to default them. If you have no default provision, what's the process for defaulting? So the way to handle it, in my opinion, is to provide lots of notice and document even more thoroughly than you may otherwise, because you have no written agreement that defines the process. So lots of written notices and warnings. Don't think that because if you don't misunderstand what I'm saying. Just because you may have no written agreement doesn't mean that you have no right to terminate the contract. What it means is that the rules are a little bit more, are more vague, and as a result, you need to be more careful about terminating when you have no written agreement than if you have a written agreement that clearly defines duties and obligations and the default process. I would strongly encourage you that before you default a contractor, whether you have a great contract or you have no contract or anything in between, you talk to a construction lawyer so that you don't find yourself in a worse position than if you never terminated them to begin with. And I would suggest to you, especially if you have no written contract, that terminating the contract is should be your absolute last resort. You should not lead with termination. That should be the last thing that you do after you consider all of your other options and you talk to a construction lawyer about your rights in that situation. And with that, if there are any questions, make sure that you submit them now. Ariella will look for those questions and let us know. In the meantime, if you want some more information on liens, bonds, contracts, collections, and other construction issues, we have a weekly podcast called the Lien Zone Podcast. You can find it on iTunes, Google Play, Stitcher, or wherever you find or listen to your podcasts. They're very short, typically 10 to 20 minutes, covering a topic just like we did today. And as we do every month, and as we have done this year, we have free webinars once a month. We also will have longer form live presentations. Before the coronavirus, we would do them live about 3 or 4 times a year. Hopefully we'll be able to get back to that in 2021, but go to sunraynotice.com/education. Within the next week or so, we will have the 2021 calendar of topics for these free webinars posted there, and you will also receive an email with those topics and dates. Ariella, do we have any questions?
So far, we do not have any questions, but what happens from time to time is right after the webinar, you go, oh my goodness, I wish I had asked this one question. So on our next screen here, Alex, we have our contact details. So if anyone does have any questions, they could certainly reach out. I highly recommend, even if it's a contract review, reaching out to Alex Barthet so that in 2021, you do not find yourself in the same position that you're in right now, because clearly the majority of people who are listening and who will be listening to this webinar have an issue that can be prevented in the future. So please make sure that, and again, in 2021, that you're in a strong position and this doesn't happen to you again where you have a sub that you just, you go from wine to whiskey because you just can't get them off the project. Alex, it apparently did such a sensational job that at the moment there are 0 questions.
Great. Well, thank you everybody for attending. I look forward to seeing you at our 2021 events. Thank you, Ariella.
Thank you so much. And everyone, happy holidays and the last night of Hanukkah, and happy and a healthy new year to everyone.